So today's class is what you need to know about real estate. Sorry, okay. Hi, how are you? Good, come on in. Okay, let's get started. So we're going to talk about a few things. I see a lot of agents on here. Some of you guys have been in the business for a while. Some are newer. This is going to be a pretty basic class about what we need to know to stay compliant. And it might be a refresher for some of you guys. So the first thing I want to talk about is advertising. So Ohio laws, licensing laws talks about how we can advertise. So do we all know that our name has to be on our advertising as well as our brokerage name, right? Yeah. Brokerage name needs to be of equal or greater predominance than the agent or the team name. If you're on the team, you're allowed to advertise your team name, but there always has to be a licensee name on there too. So if you're advertising the team, just make sure that there is a licensee on that advertising too. Do we all know what our brokerage name is? There's a couple choices here. Keller Williams Living or Keller Williams Living. Anybody want to take a guess at which is our brokerage name? No. As far as the state's concerned, it's just Living. Keller Williams is a franchise name. So as far as the state of Ohio is concerned, our brokerage name is Living, which causes some confusion with the predominance because we have our logo that says KW Living, right? And when we're looking at when somebody asks me if their advertising is compliant, I'm only looking at the word living. I'm not looking at the whole logo of Keller Williams, because when the state looks at it, Keller Williams is nothing to them, right? So knowing that, and knowing that it has to be equal or greater predominance with our name, I've put a couple examples up here. Anybody want to take a guess at which one's correct? We'll call this one. This one will be 1, 2, 3, 4. So if the top left is 1, top right is 2, bottom is 3 and 4. 3. Anybody else want to take a stab at it? Yeah, 3's right. That's correct, because the word living is more predominant. Keller Williams Living Realty, there's no realty, it's just living. Option 2, my name is more predominant than living. Number 4 doesn't even have living, just says Keller Williams, so that's not right either. When we're advertising listings, we just need to make sure that, first of all, if it's your own listing, you have permission to advertise it. It's in our listing agreement, unless a seller, for some reason, decides to strike out some of that language. They're giving you authorization to market the property. So if it's your listing, you're allowed to advertise it. Does the listing belong to Keller Williams Living? So if it's my listing and you wanted to advertise it, all you need to do is get permission. What's going on? Can you guys on Zoom see my screen?
Yes.
Yes.
Okay. I don't know what's going on here. Hang on. There we go. Hopefully that works. Okay. So if it's my listing and you guys want to advertise it, it's probably okay, but you just need to check with me first, or whoever that listing agent is. Say, hey, I want to advertise this new listing of yours. Is that okay? Get written permission from the agent and you're good to go. Um, if it's not a Keller Williams listing, and you still want to advertise it, you need permission from the other broker. So if it's whatever, whoever the brokerage is, just you should reach out to that agent in writing. Make sure you have it in writing. Say, hey, I want to throw a Facebook ad up about your new listing. Is that okay? They say yes or no. If they say yes, go ahead and do it. Make sure you save that email or text if it's a text message, make sure you save that text message as a PDF. I would just do a screenshot, save it on your computer somewhere so that you always have that in case there's ever any question about advertising that. Just make sure you do courtesy of whatever brokerage, and make sure that your name and Keller Williams, or make sure that your name and living is advertised. And the predominance rule still applies. Okay, so the basic idea is if it's not your listing, just get permission. Technically, if it's another broker's listing, you need permission from the broker, not necessarily the agent. But I would say if you get it from the agent, you should be covered. Okay. If you're doing any advertising in the mail, your return address needs to be the office address. You cannot use your home address, even if if you don't come into the office and you work from home, that's fine. But return addresses always have to be the address that's registered with the state of Ohio with the Division of Real Estate, and that's the address in Solon. Social media. So we know that that's become a lot more popular recently. So you just want to make sure that you're compliant with the one-click rule. So a lot of people are throwing stuff up on social media. It's hard to follow the licensing law on social media with the brokerage name and the agent licensee's name and all that stuff. You need to make sure they have what's called the one-click rule. Is that within one click of that advertisement, they need to know that it's that you're doing something as a licensee. I feel like I keep on seeing flashes. Is the TV going in and out still? Okay. So just make sure that you're compliant with the one-click rule. My rule of thumb is just if you're posting a picture, just throw it on there, your name and the company name, the brokerage name. That's the easiest way. But if you're doing it through a link back to your website or something, that would be compliant, because within one click, you're not doing multiple. You're not going from one website to another to figure out that you're advertising as a licensee. Within one click on social media, the consumer needs to know that you're a licensee. Cool. Yeah.
So like on Instagram, if I was to post it, if I said, Mom, someone want to click something, if I put link in bio, maybe someone in my profile, that's one click.
Yeah, link in bio would, I'm not very proficient with Instagram, so I'm not sure, but I know that you can't do a link in your description, right? You can't put a picture and then in the post put a link, right? So it has to do that link in bio and then on your I can find out about that for you, or the solution would be, again, just to put your name and Keller Williams Living's logo on there, and then that picture is compliant, and then you could still do link in bio, but as long as that photo is compliant, then you're in good shape. All right. No signal.
Rick, I have a question.
Yep, go ahead.
My hand was raised, sorry.
Oh.
I'll lower it.
Yeah, I'm not good at seeing all that stuff. So yeah, just
Yeah.
unmute yourself and interrupt me if you have questions.
Yeah. So what if you're doing a live and you're talking about an upcoming listing or an open house or anything, and it's just Facebook Live? There's no way to do that.
Well,
Would you just say,
Yeah, I think you're fine on the live because that's a live video and you're the licensee and you're presenting yourself as a licensee, right?
Yeah,
So I think you're fine on the live. Yeah.
okay.
Okay. Um, okay. Hopefully the TV keeps on working now. So MLS rules. So a lot of this is going to change in the next couple months, guys, with all the changes that's happening in our industry. So I'll tell you what it is now. Just be aware that you might get different instructions from me in the coming months. But so to start off, we got a new listing. We need to input it in the MLS, right? You guys are responsible for doing your own MLS input. There's MLS classes. You should take that. I think you're required to take it for them to give you access to do input. So make sure that if you haven't already taken that, that you take that class. The different statuses in the MLS. It's active, which we all know it's available, right? There's under contract allow showings, or UCAS. That means a lot of us use the term contingent still. That's what we used to call it. It means you've accepted an offer, but I'm the listing agent. We've got an accepted offer. You've got a buyer. You still want to show it. Maybe they're interested and you do a backup offer in case something happens with financing or inspections or any other contingency. Then you've already got your offer in there. So that's what under contract allow showings, or UCAS. UCNS, under contract no showings. A lot of us call that pending. It's just that you've accepted the offer and we're not taking showings anymore. Temporarily off the market. It's on here, covered up by my thing. Temporarily off the market means just that it's where it's listed, it's your listing, you have your exclusive. We're not showing it right now. When it's temporarily off the market, you cannot let anybody in. I don't care if they say, oh, we're only in town this weekend and this is our only opportunity. We're going to buy a house this weekend. If it's temporarily off the market for any reason, that means nobody's going in to see it. Okay. Now, if somebody wants to make an offer sight unseen, we can still accept an offer, but you cannot let anybody in, not your client, not my client, nobody is going in when it's temporarily off the market. There's also a rule about temporarily off the market. If you've got a home that you've blocked off showings for more than 2 days, so 2 days you're allowed to keep it active, but once you get to that third day of no showings, then it needs to be in temporarily off the market status. So I've got family coming in, no showings Friday, Saturday, Sunday. That's fine, temporarily off the market. And when it goes temporarily off the market, the rule is in the broker remarks, you need to put in what your expected date is to come back on the market. You don't always know that date. I just had one that went temporarily off the market recently because they had a flood. And so they were getting insurance in and getting floors redone. We didn't know how long that work was going to take. So we made a guess and I put a date in there and it wasn't ready by that date. So we changed it. So you can always change it. It's not set in stone whatever date you pick, but the exception to the blocking showings for over 2 days would be if it's tenant occupied. And so we see a lot of investment properties, no showings until accepted offer. That's okay. Or if there's a condition in the property where it's not safe for people to be walking through, then that's an acceptable reason to have no showings for over 2 days while it's still inactive. But most of the houses that we're listing, if somebody's just got guests in or something going on, it's got to be temporarily off the market. There's also the NAR clear cooperation rule. That is 24 hours after you do your first advertising of a property, it's got to be in the MLS. So that means you put a sign in the yard. The 48-hour, I didn't talk about the 48-hour rule yet. there's a 48-hour rule and there's a 24-hour rule. Once you do any advertising, a sign in the yard, a Facebook post, anything, you've got 24 hours to put it in the MLS, so that it's available to any agent. If you're not doing any advertising, then that 24-hour rule doesn't apply. Then you have the 48 hours. The 48-hour rule with the MLS is simply you have 2 business days. It's not really 48 hours. It's 2 full business days, to put it in the MLS after you take the listing. So
NAR.
National Association of Realtors. Yeah. So does that make sense? The 24 and 48 hours, we all understand?
But the 24 hours is just calendar period, 24 hours within that one day. It's not business days as opposed to 40 hours in business days.
I'm gonna say yes, and I don't know if that's the right answer. For those on Zoom who couldn't hear the question, the question is the 24-hour rule, is that one business day, or is it 24 hours? I'm gonna say 24 hours, and I'm saying that without a lot of certainty because I've asked that exact question, and depending on who you're talking to, you get a different answer. So I would say, just to be safe, 24 hours. Now, I can tell you, I've spoken with the MLS is the one that enforces this NAR rule, and I've talked to them because there's a house in Shaker Heights that's had a sign out in the yard for months, and it's not been, well, now it's in the MLS, but for a long time it was not in the MLS. So I did call the MLS and I talked to them about it. And so what's interesting is the rule is it's only if you have the listing. So if I've just, I may have signed the listing with you today, but we're starting our listing, our exclusive right to sell. Well, you signed it today. The date that it's actually going active might be next Monday. I can put a sign in the yard today and the 24-hour rule does not apply. The reason is I don't have an exclusive right to sell until next week, Monday, right? Now you're at risk. If you're doing that, you better know your client isn't going to push you out of the deal, because now I've got a sign in the yard and somebody ends up buying that house before Monday. Technically, I didn't earn my commission because my exclusive right to sell only begins next week, Monday, and not today. So in that case, you could put a sign out and the 24-hour rule doesn't apply because you don't have an exclusive right to sell yet, right? Even though it's signed, the listing starts next week. Does that make sense? Okay. Does that make sense to everybody on Zoom, hopefully? All right. And then the 48-hour rule, which I didn't really cover, is so you have 2 business days to put it in. Now this rule I know is business days, not hours. So I took a listing, goes active today. What's today? Thursday. So Friday would be day 1. We don't count Saturday, Sunday. Monday is day 2. By 11:59 p.m. Monday, it needs to be in the MLS. Okay.
We said it's 48-hour rule is calendar day.
Yeah. Yeah.
Yeah.
Calendar. Yeah. And it's not truly 48 hours because it's 2 full days, basically. Right. And today would be day 0. If my listing is for today's day 0, tomorrow would be 1 24-hour period. Friday would be the first 24-hour period. Monday would be the second 24-hour period. So by 11:59 p.m. on Monday, my listing would have to be in the MLS.
So it's calendar business days.
Yeah. Now, if it's a holiday, if it's a postal holiday, the government's closed, then we don't count that those days. All right. More about the MLS. We pay our dues every 6 months. It's $228 for a 6-month period. Okay. We just paid it in March. Next time we pay it will be September. If you're a new agent, then your fees will be prorated. So when you join the MLS, you would have to pay. If you joined today, you'd pay for, I guess, 5 months instead of 6 months. They would prorate that $228. One of the benefits we get from MLS now is Supra key access, which I wish people would use, but nobody uses it. So if you go down, I think in like Summit and Stark County, they might use it more than we do here in Cuyahoga area. But those are just e-boxes. They're the big electronic lock boxes. They don't have a combination. If you don't have a Supra key, you can't access it. The Supra key is on your cell phone. It's an app, and it's free. So I have it. I couldn't tell you the last time I used it because nobody has those boxes. But it's just an app that you need to download, and we get it for free with our membership. Photos. We have to have at least one photo with our listing in the MLS. That one photo. Anybody know what picture that has to be? Exterior front. We have to have a minimum of exterior front picture in our MLS. We're allowed up to, I think they changed it. I think it's 50 photos now. Used to be 35. I think they added it up to 50 now. But you have to, at the very minimum, you have to have one photo of the outside front. And then this is a big one. This last one on this slide is a big one. This is part of the whole lawsuit stuff that's been going on. So we do not work for free. We can never advertise that we're working for free for a buyer. For sellers, obviously, they're paying us the commission on the listing. But for buyers, we cannot say that we work for free, even if we're getting paid by the listing from the seller's proceeds, like is customary. Because we're not working for free. We're getting paid, right? I mean, none of us are doing this as volunteer work. So while our client may not be directly writing us the check, we're still getting paid. So we cannot ever say that our work is free. Okay. There's some numbers that you might need to know through while you're writing contracts and things. So our office license number. People always get confused with the third one down, our MLS office ID. They are not the same. The office license number is from the state of Ohio. That's goes on the last page of our purchase agreement. It always asks for our license number, our brokerage license number. So our brokerage license number is the 2020 number here. Okay. Very rarely, but occasionally you might be asked for an EIN or a tax ID number. So if you ever get asked that, it's unlikely to happen, but if you ever need it for something, the only time you might need is in the case of a referral. If you're receiving a referral fee, then they usually ask for the what's it called? Not the I-9, the W-4. Is that what it's called? The tax form that shows our office information for making a referral payment. We have that form already in .loop, and this number is already printed on there. So that's probably the only occasion that you guys might be asked for the EIN or tax ID number. Our MLS now office ID is 9181. That's different from our license number. That is just how the MLS identifies our brokerage. If you guys are doing any HUD deals, HUD homes are becoming more popular again. So if you ever have a buyer that wants to write an offer on a HUD home, first of all, you have to call me because I have to add you to the HUD home store. It used to be that if you had these numbers, you could just log in and do it. Now we have to have each agent registered. So before you write an offer, you'll have to get in touch with me. And then you'll need this NAID ID, NAID number. And that's how HUD Home Store identifies our brokerage. There's also something called a NERDS ID number, or I think they changed the name to an M1, but I think most people still call it the NERDS ID. That is your NAR ID number. So when you join NAR, they assign you that membership number. And that number is unique to every single agent. Mine's different than yours. And it stays with you forever. So as long as you're a member of NAR. Okay. Commissions. So antitrust laws. So this, I probably need to rewrite this slide now with everything going on, but antitrust laws, we're never allowed to talk about our commissions. That's a big part of what that lawsuit was. They called it a standard commission. And even though we don't have standard commissions across brokerages, we are allowed to talk about our commissions within the brokerage. So I'm allowed to talk to you about what I charge, what you charge. We're allowed to have those conversations within Keller Williams Living. The problem is when we talk about what we charge outside of our brokerage to other agents who are not with Keller Williams Living. This is going to change. Right now, we offer a co-broke in the MLS, right? So we list in the MLS, however, whatever you're paying, right? There's no standard. You got to make sure we understand that there's no standard commission to be offered. As of well, no, they changed it. I was going to say as of now, we have to have some sort of cooperating compensation, but they changed it. We actually don't have to offer a cooperating compensation in the MLS, but I think we all know that most people do, most agents do, and most sellers would want us to be offering some sort of cooperating compensation. So you might see something like 3%, you might see 3/2%, you might see 2.5%. So the 3/2, or depending on the price point, it might be 3/2/1, some sort of graduated. Typically what that means is 3% on the first 100, 2% on everything else. You might see 3/2/1 if it's a higher end. There's going to be some other cutoff point where it gets graduated down even further depending on the price point of the house. Currently, our MLS is our contract for commissions. That's going to change in July, the latest, assuming that the settlement gets approved by the court, which I think we all think it will get approved. But currently, our contract for commission is the MLS. So if the MLS says you're getting 1%, that's what you're getting. When we agreed to be members of the MLS, we agreed that whatever the compensation being offered in the MLS is what we're getting paid. So if it says 1%, if it says 10%, that's what we're getting. Now, we should all get used to writing buyer exclusive right to represent agreements. And so if you do have something that's offering you $1 or 1% or 0, your buyer agreement will protect you that that's what you're getting paid. So if I have a buyer agreement that says, you're my buyer, you're agreeing to pay me 3%, and you want to buy this house and the MLS is only offering me 1%, the buyer's going to pay me 2% difference. So I'm getting my full commission. In July, we're no longer going to be able to advertise commissions in the MLS, and we'll see how that plays out. Things will change. I'm not really prepared to talk right now about what that's going to look like in July, because I think we all need to get our heads wrapped around it and see how it plays out. There will still be cooperating compensation offered. Number one is this bullet point about our contract for commission is through the MLS. That's going to be gone. They're not going to offer us commission in the MLS, and it's going to be negotiable in our contracts. And we are allowed to offer cooperating compensation in other advertising. So it may be a flyer that says I'm paying 3 and 2 commission to a buyer's agent. It may be a text message. There's going to be other avenues to offer cooperating compensation, but it won't be an MLS anymore. To get paid your commission, there's required forms, and this isn't my contract class. I have that next month, but you need to make sure that you have all the forms. If you're missing any forms, if you don't have your consumer guide to agency, we're not paying you the commission. If you don't have an agency disclosure, even the home warranty signed or waived, you're not getting paid out. So you need to make sure that when you turn in your file and when your clients are signing everything, you need to make sure that you're organized and have everything together so that you don't we don't have to delay your commission being paid out. And then we have an additional commission of $295 that we charge to every client, whether they're a buyer or seller. Couple exceptions to that is VA and FHA are not permitted to pay any commissions, so we waive that in FHA and VA deals. And rentals, we don't charge it for a rental commission. If you choose to waive that $295, that's a business decision you can make. If that makes sense for you, then you can always waive it. Just know that unless it's VA or FHA, the office isn't waiving it. So I have investors who buy a lot of properties with me. They don't like paying me the $295 additional commission. They've bought enough properties where I say, okay, I'm going to waive this $295 for you. And when I get paid when the office receives the commission check and it's only 3% or whatever the total commission check is, they're taking the $295 out of it. So the office is getting it one way or the other. It's my business decision. This guy's bought 10 houses from me in the last 2 years. I feel comfortable that I don't need to charge him the $295, but the office is still getting it. Does that make sense? All right. Showing times. The unmute. Greg, you have a question? Or?
Sorry, no, I'm done. Thank you.
Okay. Oops. Shoot, how do I go back? There we go. Showing time. Okay, showing time. Some people call it CSS still. They haven't been CSS for a while, but a lot of people still call it that. So they're just our showing service. We have them here at Keller Williams Living. It's part of your monthly fees that you have, the membership there. It's something that we cover for you as part of your monthly fees to the office. It's great because when you take a listing, you're not the call center and getting 10 calls from agents who want to come see your home, right? Your listing. It's just a call center somewhere in North Carolina, I think. And all they do is I took a listing, I gave them my showing instructions. Now, when you want to show it, you call showing time and they know how to get in, when to approve it, how to approve it. There's 3 different types of showings. There's a go and show. It's great for vacant homes, right? So the seller doesn't need to know it's empty, that nobody needs to approve an appointment. The seller maybe wants to be a little bit more hands-off and doesn't need to know every time somebody's coming to see their home. So go and show is great for that. There's also a courtesy call, which is also, I would say, typically good for vacant homes, but that's for the seller who says, okay, we don't need the appointment, but I want to at least know that somebody's coming tomorrow at 1 o'clock. So the courtesy would the showing company, the showing time would just approve it. I call, they say, sure, you're good to go tomorrow at 1 o'clock. And then they call and they give me the lockbox code and everything. And then they call the owner or text the owner and say, Rick's going to be there tomorrow at 1 o'clock. So that's a courtesy call. Appointment required. That's great when you have a home that's still being lived in. And I call, I say, I want to show that listing tomorrow at 1 o'clock. They say, great, we have to get approval. We will notify you once we get approval. Then they call, text that seller till I get approval. Then they give me the showing instructions once they get approval from the owner for that showing. So anytime you have an occupied home, that's probably the type of appointment that you want to do as an appointment required. So showing time is nice because it saves you time from being the call center. And it's also nice because they collect feedback. So after your showings, you'll notice you get an email from Showing Time saying request for feedback on 123 Main Street. And then you can go in there and provide feedback to the listing agent, to the seller. You know, home is nice space, it's too outdated, too expensive for the updates it needs. I would say it's courteous thing to do for an agent to provide feedback. And as a listing agent, it's great information because then I can go back to my seller and say, look, we have all these showings and the feedback says it's too dated. What that means is it's too dated for the price, right? So you can use that to get price reductions. You can use that to justify your price. That, you know, we've got a lot of great feedback and we're expecting offers, so let's leave the price as is right now. Showing Time?
Yeah, I mean, you said, is it computerized feedback or verbal?
No, it's all done on email. So after you show a home, as a buyer's agent, you'll notice you get an email saying, please provide feedback. Right. So if I'm scheduled for today between 1 and 2, at 2:01, I'm getting an email from Showing Time saying, please provide feedback. Yeah. There's a lot of great.
Here, Rick,
I'm sorry.
I'm hopping in for 1 second.
Sure. Go ahead.
You know, it's funny as when the market cools a little versus, you know, when it's really hot, but so often agents just don't leave feedback, you
Yeah.
know, and one of the things that I always tell my seller clients is, look, if we're not getting feedback, generally that means they're not interested, but it would still be a professional courtesy for the
Yeah.
agent to take the 1 minute that it takes to fill out the feedback, even if you've shown 15 homes. I would literally back legislation that said you can't show a home if you don't fill out feedback, you know, 90% of the time. I mean, it's crazy how many
Yeah.
agents do not do this. And I just stress to anybody who's new or listening, not to be a total pain in anyone's butt, but like we are getting a professional courtesy to walk into someone's home, whether it's a HUD home, a bank owned, or Mr. Smith owns it. And it is our duty to leave feedback, any kind,
I
anything.
agree. It's a
Yeah.
professional courtesy. Yeah,
Yeah.
absolutely. I try to do it with every time I show a house. I try to leave some feedback. Sometimes it's useful, sometimes it's probably not. But I'll leave whatever feedback I can give so that the listing agent, because I know I appreciate when I'm the listing agent, I really appreciate getting that feedback because I use that to either justify my pricing or to use that to say, hey, we're overpriced. We need a $10,000 price reduction. So the other nice thing, there's all sorts of reports. If you log into Showing Time and you start playing around, there's so many different reports that you can pull out of there. I've used it for buyers and sellers. I think it's really a seller's tool, but I've used it for buyers. You can put in criteria of your listing and see homes in Solon priced between 200 and 300. There's been 10 requests in the last week for those listings. So now we know, and then we can see if we were at 175, are there more requests between 175 and 200, or should we be right at 2? It's a great tool to use. I've also used that. I flipped that around. And I've had agents telling me, oh, there's tons of interest in this house. You better hurry up and write us an offer. And I've questioned that. And there's been times I've flipped that around and I've gone into showing time and put in the criteria of that particular home to see that there's been no showing requests or very few showing requests. So it's just a good tool that you can use um, for mostly for sellers, but even for buyers sometimes. All right. Who signs a listing agreement or a purchase agreement? So is it a single person? Then they're the only ones that's easy. They're not married, they own the house, they sign it, right? That one's easy. If they're married, take me for example. I'm married and my name's the only one on the house, but I can't sell my house without my wife's signature. So despite, if you were my listing agent, despite pulling up the public records and seeing that only Rick Tannenbaum owns that house, you better be sure to get Allie's signature on that too. Otherwise, she can stop the whole thing and it's not a legitimate listing. So if they're married, make sure that you have both signatures. If it's a trust, you need documentation. If the property is owned by a trust, you need documentation for that trust. Don't take somebody's word that I'm the trustee. You need to see that trustee document. You need to make sure that they truly are authorized to sign for that trust, number one. Number two is sometimes people don't even understand how their trust works. They may be co-trustees. So I have a trust and both my wife and I are co-trustees. That means that if the trust owned the house and you're a listing agent, you need both of our signatures, not just one. There's also successor trustees. So if somebody passes, then it automatically goes to this person as the trustee. So that successor trustee is not a trustee. If the trustee is still alive, the successor trustee has no right to sign any documents. So you need to see those trust documents and you need to make sure that they are allowed to sign what they're signing for the trust. And then there's estates. A lot of times we get into multiple siblings. I had a house that was in the estate and there was 4 sisters and all 4 of them were married and I needed 8 signatures on everything. Hopefully if you run into a situation like that, hopefully there's one lead person who's making the decision and they all agree that this person's the lead. But just because that's the decision maker doesn't mean that's the only signature you need if it's set up like that. So divorces, again, you need to make sure that you're doing this right with a divorce. If they're still married, if the divorce is not final, you still need both spouses to sign. If they're divorced, the divorce is final, you should probably check the divorce decree, and you might even want to see a quitclaim deed. So many times I've seen one spouse receives the house in a divorce and they have a quitclaim deed. It was signed with their divorce papers, but the divorce attorneys never bothered to file that quitclaim deed. So as far as the county is concerned, both of them still own it. I've seen that happen a bunch of times. Divorce was finalized 5 years ago and nobody ever filed that quitclaim deed. So in those cases, we've had to chase down attorneys who have to dig through their files. Depending on where we are in the process, we may just hand over that quitclaim deed to our title company who's closing our deal. They could file the quitclaim simultaneously, or if we're not quite there where we have a purchase agreement, we might want to ask that attorney to go file that and record that quitclaim so that your client is truly authorized to sell. Dowry rights. We all know what dowry rights are. Some of you guys are newer licensees, probably have it still in your mind from Hondros. The state of Ohio is one of 3 states that still has dowry rights. What that means is I can go buy a house today and keep it a secret from my wife and nobody can stop me. But if I wanted to sell that house, she has dowry rights. She's an owner of that house, whether she's on title or not, whether she's on a mortgage or not. I can purchase the house. I cannot sell the house without her signing off on things. Most of our clients are probably getting mortgages. So when you're getting a mortgage, the lender's not gonna let that slide. Um, and then the lender's gonna want the spouse to sign off on their dower rights, saying that they understand that. So cool. By the way, the same thing, it's not on the slide. The same thing goes for LLCs. A lot of buyers are purchasing in their company name. You need to see that they are really the managing partner of that LLC or an authorized agent of the LLC to be able to sign. And same thing with POAs, power of attorneys. Those documents need to be notarized. So if you're selling something and somebody's got a power of attorney that they're signing off on it, that's fine, but you need to have a copy of that, same as the trust. You need to have a copy of that power of attorney, and you need to make sure it's notarized. MLS is cracking down hard on this. I don't know if you guys saw, there was an email that was sent out, maybe, was it 2 weeks ago, maybe now? They're cracking down on this, and I think that's partly because of wholesalers listing houses that they don't have a power of attorney for. But yeah, they're checking to make sure, and you will get fined. And I think with that stuff, I think they're even doing MLS suspensions. They're gonna suspend you from the MLS if you don't have the right signature. So if I've got a power of attorney, you better, before you list it with me, you better see the copy of that and make sure it's notarized. Okay.
And what about if it's out of state, like the house is here, but they live out of state?
If the notary stamp is from out of state,
Yeah,
I don't
and
think,
the clients are out of state.
no issue if they're out of state, as long as it's notarized. If there's ever a question about it, I've done this before with power of attorneys where I've questioned whether, because there's a million different types of power of attorney. And just because you have a power of attorney doesn't mean you're allowed to sell be the signer for them for a real estate transaction. There's different types of power of attorneys, and you need to make sure. I've had clients tell me their power of attorney and that they have authorization to sell this house, and I was unsure. I just took it to my title company partner and asked them to verify that this is a valid power of attorney for the transfer of real estate. It may be a valid power of attorney for other things, but it has to specifically say that they're allowed to sell real estate, or maybe it says assets, sell personal assets, but not every power of attorney gives them the authorization to sell the person's real estate. Yeah, so when in doubt, just, you can ask me, or if I'm not sure, I often just run it by my title company partner. Okay, escrow letters. Escrow letters we have in our dot loop. You just need to fill it out and get it to the title company so that they know how to pay the commission, right? So it's got all the pertinent information about the contract on one page. It tells you who the buyers are and who the sellers are. It tells you what you're expecting that your commission is. Is there a home warranty? Who's paying for that home warranty? How much does that home warranty cost? Are there closing cost credits? Who's, sellers giving buyer credits, buyers giving seller credits, whatever the case may be. Inspection invoices is pretty rare, but if sometimes I've had people that have had repairs done and they didn't have the funds to pay the contractor for the repair, and the contractor said, we're closing in 2 weeks, I can wait 2 weeks to get paid, and we submit the invoice to title to pay it out of the seller's proceeds. If that's going on, you would need those invoices, would be outlined on there, and you would send the title company a copy of those. Co-broke information goes on the escrow letter, closing dates, lender information. It's pretty self-explanatory. I mean, the letter, you just fill in the blanks, and it's fairly self-explanatory. Where it sometimes gets the title company confused is if you ever pay for a home warranty. This is what I found. Sometimes I pay for a client's home warranty myself out of my commissions. And that's where sometimes, because that's not specifically an option on the escrow letter. Sometimes that causes confusion. So you should just write it in there and explain it the best you can. You might need to follow up with the title company and make sure they understand that. I recently had one that they were a little confused about what was actually a referral fee. We put the total commission to buyer side, less a referral fee that was being paid to another brokerage. They were confused. What's the total commission for my side of the deal? So every once in a while you need to clarify with them, but otherwise it's fairly straightforward, fill in the blank form. Choosing a title company. This gets everybody worked up. Who gets to choose title company? So RESPA says buyer gets to choose title company. RESPA says whoever's paying for the title policy gets to pick the title company. So if a seller is paying for all those title closing costs, then the seller gets to pick it. It's customary in our area that it's split 50-50, and that's why people get upset and get in a fight over a title company. What I would say is, what I do is most buyers and sellers don't know any title company. They just usually don't, right? So it usually ends up being the two agents butting heads. I want to use mine, you want to use yours, who's going to win? Never lose a deal over a title company. There's a few title companies that may be worth losing a deal over, but there's not many. At the end of the day, if it's American Title Solutions or Affinity Title or Ohio Real Title, those are the three big ones I think most of us are using. The fees are all the same. The service is all pretty good. American Title Solutions is the title company that we're affiliated with at the brokerage level. I know there's some agents that are affiliated with Ohio Real Title. I know there's several agents that are affiliated with Infinity Title. You're not going to save much money going from one title company to the other. Most of them, first of all, will match fees. So if you find that one title company is cheaper, most of them will usually match those fees for you. And I don't know, you'll save $20 on this fee, but you're going to pay $20 more on that fee. At the end of the day, they're mostly they're within a few bucks of each other. You're not going to save. It's not like you're going to save hundreds or thousands of dollars by going with one title company over the other. So it's never worth losing a deal over a title company. That's my position on it, and I think most title sales reps will tell you the same thing. You know, they want your business, but if everything else in the contract is good for both parties, don't lose it over my title company versus your title company. Now, if you are using American Title Solutions, we are affiliated with them, so we have to have an ABA, affiliated business arrangement disclosure notice. That's in .loop for you. That's just notifying your client that the brokerage has a financial interest in that title company. If you guys, I know some people on this call have their own affiliates. When you have an ABA with another title company, they should give you that ABA form, and you need to make sure if you're using another company that you are using the correct form. But as far as the brokerage is concerned, only if you're using American Title Solutions do you need that ABA form. If you're not using American Title Solutions, you don't have to have that signed. Okay. Home warranties. Our home warranty form is a required document. Whether your client is taking a home warranty or not, we need to have that home warranty order form in your loop and turned in with your file. There's two different places your client can sign it. There's the at the bottom of the page, there's the top section, which is acceptance. They're accepting the America's Preferred Home Warranty, and they sign that they're getting it. At the bottom of that page, there's a waiver. So if they choose not to take the home warranty, they would sign the bottom, the waiver. The reason that's a required form and they have to sign a waiver if they're not taking it is because America's Preferred Home Warranty does help us with any legal fees. If there's a lawsuit around one of your transactions, they help cover our E&O, our deductible and our E&O policy. They help us with that even if your client does not take the home warranty. They help us with that as long as they know your client has had the opportunity to take that home warranty. So if they waive it, they know that it was presented to them and they chose not to have it. Same goes for if you're taking another home warranty policy. If they're choosing not to take America's Preferred Home Warranty because the listing agent was offering the home with a HSA policy, that's fine. Take the HSA policy. They still need to waive the America's Preferred. Okay. The warranty cost $4.99, paid at closing. And it comes with $100 deductible. So if there's a claim, the client pays $100. They come in and they repair or replace whatever the problem is. And of course, there's an asterisk there because there's all sorts of limits, like, you know, if your hot water tank breaks, don't tell your client for $100 deductible you're getting a new hot water tank, because they're probably not. I think it's $1,100 max benefit. That's probably what does a hot water tank cost these days? Probably $1,800, maybe $2,000 to have a new hot water tank installed. So they'd be responsible for the $100 deductible. The warranty would kick in and pay the max benefit up to the max benefit, and then the balance would be your client's responsibility.
So where's the max benefit? Is it that all written out?
There's brochures for that. So yeah, you should be able to find it in the brochure or on their website. And sometimes I have trouble finding what those benefits are. And I just call Renee, who's our customer service representative from America's Preferred. So I've called Renee. I was pleasantly surprised. I told these out again. I told a client they were having trouble with their furnace. They have two furnaces, two air conditions. It's a larger house. Brian, are you online? We're having trouble with this TV here. If you're not, then I'll try to figure it out. 2350 is the max benefit for HVAC. At least that's what I told them it was. And then Renee corrected me. It's actually 2,300 per unit. So I take that back. It was not two furnaces, two ACs. It was a problem with both the furnace and the AC, and they got 2,350 for the furnace and 2,350 for the AC. So Renee's a great resource for that stuff, and a lot of it you'll figure out from reading the brochure. Okay. Consumer guide. It's really important we get these consumer guides signed the first time we meet with our client or with the consumer. They're not our client yet at that point. The one exception to that is if you meet them at an open house. We're not expected to have everybody coming through an open house to sign a consumer guide. But we do need to make sure that they're presented with this before we get into anything confidential. Before we talk about their finances, before anything that might be deemed confidential, they need to understand how agency works in the state of Ohio. So that's why it's so important that we present this to them the first time we meet. They do not have to be signed for every single property. If that investor of mine, for example, I'm not having him sign one with every purchase agreement. He signed one. It's good for 3 years. Every 3 years, I make sure he re-signs one. Okay. A lot of our agents like to get them signed only when they're writing the offer, and that's fine until the Division of Real Estate audits your file, and then it's going to be a license suspension. So I would recommend not doing that. Just getting it signed the first time you meet with them is the best practice. Okay. Showing a house. Just there's a lot of stuff on here. It's mostly just common courtesy, professional courtesy stuff. When you're showing a house, make sure you pay attention to the remarks. It says leave the lights on because there's people coming in after you. It says take off shoes. It says shut the door because we don't want to let the cat out. Just make sure you read all that so that you're being courteous to the owner. If there's cameras in the house, you should know that. They're supposed to tell you that beforehand. So the state of Ohio, if you're a listing agent, you should know this. And as a buyer's agent, you should also be aware of it. The state of Ohio, it's a felony to listen into somebody else's conversation. So if you have cameras, if you're a listing agent, there's a section in our listing agreement that we should be reviewing with our clients when we take that listing. And it talks about electronic surveillance. And the reason we ask that question is because if your cameras are recording audio, it's a felony if you're not party to that conversation. So right now, somebody could be recording our conversation. If you're recording me, you don't have to disclose to me because you're a party to this conversation, right? So when I'm in a listing appointment, somebody's recording me without my knowledge, that's fine because they're party to it. But when they leave the house for a showing and I'm in there with my client having a conversation, we have the expectation that our conversation's private because you're not there, right? That's where it's a felony. So I tell people if you've got cameras, leave the video rolling, but disable audio. And if you can't disable audio, if the Ring doesn't allow you to disable just audio, then I recommend to turn it off. And I make sure that they understand that if they have that, they could get in big trouble. At the same time, when I'm with a buyer, I mean, I see cameras around houses all the time. And I just tell my client, while we should be able to expect privacy in our conversation, just don't expect it. If we see a lot of cameras around, a Ring doorbell or whatever, maybe we just look and have the conversation back at the car somewhere. Although we should have that expectation of privacy. Being on time, leave a card. There's a couple of good reasons to leave a business card. The main reason we leave a business card is so that the seller knows that I was there when I said I was going to be there, right? And the other good reason to leave a business card is if that agent doesn't sell the house and they see that you've come back and shown it once, twice, 3 times, they've got your information. When they need a new agent, hopefully they're calling you. So there's a few reasons to leave a card. That being said, I often forget to leave a card, and I think a lot of agents often forget to, and it's not a requirement. It's just a courtesy. Turn on or off lights, make sure the doors are locked how you found them, unless there's other instructions not to leave lights and doors how you found them. Mix up the code on the combination lock boxes. Don't give out the combination lock boxes to your clients ever. You will get suspended for that if you get turned into the state. Feedback after showing, Laura already hit on this. Thank you, Laura. But it's just a common professional courtesy. And if most brokerages around Northeast Ohio are using showing time, so that whole conversation about the auto email, it's most of our showings are going to have that feedback request. By the way, if I notice something in a house, I don't always wait to provide the feedback in that email. I've been in houses where we go down to the basement, we smell gas. I'm going to call that listing agent and say, hey, there's a gas smell in the basement. You might want to get a plumber out here right away. I think, again, it's a courtesy. It's a professional. I would say it's a obligation with our licenses to to do something like that. And you know, if you find the basement's flooded or something unsafe in the property, don't just wait till you get that email. You might want to pick up the phone and call the agent. Working with other agents, be courteous. We're going to do deals. Hopefully we're going to do lots of deals with these agents, right? So we're not out here to make enemies, right? We're here to be professional and help our clients get what they want. My client wants to sell their house. Your client wants to buy the house. We don't have to be adversaries. We need to be professional and courteous. And hopefully that shows that other agent that you're a good agent too. And then the next deal that might even get you a few extra points with their client when they know that they've already had successful transactions with you. So it's not always about winning and losing. It should be a win-win. At the same time, while we're saying communicate with the other agent, you also need to remember you're a fiduciary for your client. So confidential information should not, you know, why is your client moving? What, you know, what's their situation? That's really confidential unless your client tells you you can disclose something. But so while you want to communicate, you don't want to give away too much, right? All right. Earnest money. We can never accept cash for earnest money. We all understand earnest money, right? It's not a new concept to anybody. Okay, so cash is not acceptable. Personal check, cashier's check, wire transfers. A lot of the title companies are doing ACH deposits now, which is really nice and convenient, which is essentially just a check, but it's done electronically. You put in your banking information on their website, it drafts the money out of your account into their account. Those are all acceptable ways to make earnest money deposits. There's the Ohio Good Funds Act, which says that anything over $10,000 needs to be wire transferred. We can't accept a check or a cashier's check or a personal check or even a business check if it's in excess of $10,000, and it needs to be wired. Who's holding the earnest money? That's going to be defined in our purchase agreements, and if it's our purchase agreement from Living, it's going to the title company. We do not accept earnest money at our brokerage. It's too much of a liability. I don't want to have that risk for us, so we won't accept earnest money here. Title companies can accept it, and they regularly do. If you're the listing agent, you get a offer from another brokerage, their brokerage might be willing to hold earnest money, and that's fine. If they're willing to hold it, then I don't usually have an issue with it being held with another brokerage. They're held to a high standard with that, and they can't release that money unless the proper things happen to have that money released, which we'll talk about in a second. So when you're representing a buyer, it's going to the title company, though. You're responsible for collecting that earnest money. Again, hopefully not taking a personal check in your hand, because once you take that personal check in your hand, if you lose it, it's your problem, right? So I don't like to do that. When I have a buyer, I'm responsible for collecting it, but I'm usually telling them, hey, go on this website and you can do the ACH and it takes it straight from your account. Or let me help you connect with the title company so you can get wire instructions. You can wire the funds to them. Okay. Or you want to mail a check, here's the address, you know, but it's our responsibility. In other words, if our client doesn't do that, our contract says within 4 days. If our client does not deposit that money in 4 days, then we need to make sure that we protect ourselves. We need to tell the client, hey, the contract says 4 days, we're past 4 days. By the way, calendar days, not business days for anything in our contracts. We're past 4 days, you haven't deposited that. You're obligated in our contract to do it. And you need to do that now. Then the next step I would do if my we're on day 5 and my client hasn't deposited earnest money to protect myself and our brokerage, I'm calling that listing agent saying, hey, just want to let you know, I understand the earnest money was due yesterday. Client still has not deposited. I followed up with him. I've told him his obligation to make that deposit. I've given him options of how to make that deposit. I will keep you informed of when it's deposited. As long as you communicate what's going on with that earnest money, you're covered. You're not expected to make that deposit on their behalf, but you are expected to make sure that they're following the contract and depositing it on time. Okay. How do we get earnest money back? So there's only a couple ways that earnest money is ever released out of that escrow fund. Option number 1 is we hopefully have a successful closing, and then it goes back to the buyer, gets credited towards their purchase, right? That's what we all hope happens. Sometimes we don't close on time, or we don't close at all. And then the only way that the earnest money will get released is with a mutual release signed by all parties. It doesn't matter that the contract says it's null and void if this happens. Still need a mutual release to release earnest money. And that mutual release will say who's getting the earnest money. If it's the buyer because they had a contingency and they get it back. If there's no contingencies and the sellers are getting back, if something's happened and we've agreed to split it somehow, that's all going to be outlined on the mutual release. So that's the second way it can get released out of that escrow account. The third way is if the deal hasn't closed and we don't have a mutual release, and your client wants that money back, or the buyer wants their money back, or the seller wants the money, whatever the case may be, somebody needs to go to court and get a judgment from the court to have the money released. And then the last way that it'll get released is if we haven't closed, we don't have a mutual release, nobody's bothered to go to court with it, 2 years after the deposit, it's allowed to be released to the individual who made that deposit. So if the buyer made the deposit after 2 years, they can have that money back. That's the only ways earnest money is coming out of that escrow account. Okay, any questions? Seller net sheets is a great tool. I run these all the time for my sellers when we list a house, when we start to get offers. If the offers aren't what they were expecting, or even if they are what they're expecting, they want to know what am I going to go home with? How much money is going to be left over after all my commissions and closing costs and mortgages paid off? What am I going to have in my bank account after this? So the seller net sheet, American Title Solutions has one. Most of the title companies have one. Connect with them and they can set you up with their system online. I use that all the time. I go in there, I put in a closing date, put in a sales price, I put in commissions, and then whether the property taxes, closing date affects the tax proration. Any other fees you can add in there if there's something else that needs to be added. Maybe it's tenant rent prorations or HOA fees that are getting prorated. You can add that all in there. And then it spits out a number saying, here's what you should expect. Now these are estimates, not, don't ever let your client think that this is exactly how much money you're going to have. It's an estimate. It's usually pretty darn close, but I don't want them to have that expectation and then they're $100 or $1,000 or a couple $1,000 off, and then they're upset that you told me I was going to have this. It's just an estimate. That's the end of my class. Any questions? Covered a lot. Anybody on Zoom have questions?
I have a question.
Yeah.
I don't, what would happen? Does it mean if the earnest money isn't deposited in 4 days that the contract is like void?
No. A court's the one that would say the contract is null and void. So we still have a contract until there's a mutual release signed or we close. But we have a contract. So now if the earnest money is not deposited, now your client hasn't deposited that earnest money within the 4 days, and you've done what you're supposed to do. You've told them that they're obligated to deposit it, and you've notified the listing agent that, hey, my client hasn't deposited it, but I've followed up with them today. I'm going to continue to follow up, and I'll keep you informed. You've done what you're supposed to do. The seller may say, hey, buyer, you've breached the contract. I want a release. And then, so a mutual release will terminate that contract, or going to court will could potentially terminate a contract. But no, just because they didn't deposit it doesn't mean that the contract is automatically terminated, and the seller does not necessarily have the right to put it right back on the market. Now, there's all sorts of nuances to that. So if you're ever in that position where your seller wants to put it back on the market, you can talk to me about it. And there's some little things that we can talk about and see if there is a way to put it back on the market. But no, just buyer hasn't deposited does not necessarily mean that the contract is void.
Okay, so we just need to let them know that it's, you've done everything that you can, and that you'll let them know as soon as it's deposited, as soon as you find out.
Yeah. So, and keep them informed. Maybe tomorrow you call and say, hey, I followed up with my buyer again, and I left him a message. I haven't been able to connect with him, but I've left him messages, voice messages, text messages, whatever.
Mhm.
I'll keep you informed. Just keep that listing agent informed, because the second you don't, and they find out that there's no earnest money and you never told them about it, and they decide to file a division complaint, that's where you've messed up, right?
Yeah,
That's
what
Mhm.
happens, like, if your client is on the fence about, they want to sign a mutual release to get out of buying the property because the inspection showed some things that they weren't, willing to take on, and they haven't deposited the earnest money yet. Are they still required to do that? Or is it okay if both parties sign the mutual release and they never deposit it?
Once the mutual release is signed, it's fine. But two separate issues is inspection contingency and earnest money. So I would not. I wouldn't want my client to get mixed up between those two. You have your inspection contingency. You're not happy, and you're sending a mutual release. That's fine, but we're still on day 5 of our contract, and the earnest money was due yesterday. Deposit the earnest money. You have the right to terminate because of your inspection contingency. But it's two separate issues. As soon as we get that mutual release signed, you'll get your earnest money sent back to you.
Yeah,
Okay.
Rick, I would just jump in here that
Yeah.
just now you're asking from the buying side, whoever asked that question, but on the other end, especially when you are reviewing other offers from other brokerages, read the fine print about earnest money carefully, because from a lot of our fellow brokers, there's a statement in there that says that the earnest money is not deposited until acceptance of the inspection.
Mm-hmm.
And therefore, yeah, there is no earnest money due until at that point. So, but I get that wasn't what she was asking, but just be wary, guys. Everyone's contract is written differently.
We all need to, we need to be careful when we're representing a seller. We need to read the contract, because that earnest money language might be different in somebody else's contract. And I know for sure that, like Laura said, for sure in some contracts it's different, where it's not deposited until removal of inspection contingency. I've seen that. Not related to earnest money. There's one brokerage out there that I can tell you the name. It's HomeSmart. Be careful on that one. If you have a listing and you get a contract from HomeSmart, and that buyer is FHA or VA, and they're not allowed to pay that $5.95 fee, HomeSmart's additional commission is $5.95. Their contracts say that if the buyer is not allowed to pay that fee because of the loan type, that the seller will pay it. And we've had sellers upset.
Oh,
because
yeah, Rick. I've
they've
come
got,
across that big
Yeah.
time. Yep.
So now contracts are negotiable. I don't care that HomeSmart says that. I mean, it's all negotiable. So just strike it out and have it initialed. And if the buyer and seller initial it, then your seller's not paying it. But you need to be careful with the earnest money language, with all the language. Don't assume that every other brokerage's contract is the same as us. They're not. A lot of them are very similar and some of them are very different. So we need to be aware of what's in those contracts. Yeah, I know too many agents just jump right to how much are you offering? What's the closing date and how long do you have for inspection contingencies? And they don't read anything else in that contract and that could get us in trouble. So. Any other questions today?
I have a question.
Yeah.
Going back to the escrow letter, do
Mhm.
that just get submitted to our office or to the title company as well?
That's going to the title company because that's instructions. What is going on with that TV? Plug it. That's going to the title company because that's their instructions of what the commissions are for you, what's who's paying for what. And every once in a while, I don't think it happens often, but I've had deals where there's a discrepancy between me as a buyer's agent saying I'm getting paid $10,000 and the listing agent submitted their escrow letter and it says that the buyer's agent's getting paid $8,000. And then now there's a discrepancy and that's how we figure out, make sure we're all on the same page. So no, that's you're keeping it in the loop and you're turning it into the office, but it's also more importantly going to the title company as their instructions of where the funds are going.
Okay.
Yeah. Anything else? Thanks everybody for showing up today. I apologize I was running 15
Thanks,
minutes.
Rick.
Okay. Have a great day, everybody.